Good afternoon, everyone, and welcome to Equal Rights and Wrongs, which captures several years of Schlesinger Library's exhibitions, research support, and programming around what we've called the long 19th Amendment, centered on gender and American citizenship, and anchored by the passage of the 19th Amendment in 2020, supported by the Andrew W. Mellon Foundation and the Radcliffe Institute. I'm Jane Kamensky. I'm the director of the Schlesinger Library and a faculty member in history here at Harvard. And I'm so excited to be here this afternoon with our distinguished guests and with all of you. We convene today on another historic anniversary. It's been exactly 50 years since the Equal Rights Amendment, first introduced in 1923, cleared the US Congress. ERA, as a brilliant senior thesis written by Liz Hovland, Harvard College class of 2022, has recently documented from Schlesinger's collections. ERA was a GOP-led initiative for decades, including in some Republican feminist quarters, right up to the eve of Ronald Reagan's election as president. On March 22nd of 1972, the Senate voted by a more than 9-to-1 margin, 84-8, to send the amendment to state legislatures for ratification. That same year in 72, Ronald Reagan, who was then governor of California, described the ERA's commitment to equality as morally unassailable. And here I'm quoting from Julie Suk's wonderful book. 30 of the required 35 state legislatures had ratified before a year was up. With near universal support from congressional Democrats and Republicans alike, and this is quoting Professor Suk again, the ERA seemed unstoppable. Spoiler alert, it wasn't, unless maybe it still is. Our speakers today bring deep learning and razor-sharp analyses to the history and the conundrum of the Equal Rights Amendment, and of the American traditions of rights, equality, and inequality more broadly. Each will frame the topics before us in brief opening remarks, and then engage in a moderated dialogue with each other and me, and through the chat with you in the audience. I'm sorry, through the Q&A function with you in the audience. Our first speaker is Julie Suk, who is professor of sociology, political science, and liberal studies at the CUNY Graduate Center. Holding a JD from Yale and a DPhil in politics from Oxford, where she was a Marshall Scholar, Suk approaches the topic of the American ERA from both an interdisciplinary and a geographically comparative perspective in several important articles, and most recently in the bracing and lively book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment, which is newly out in paperback. Suk will then be joined by Professor Jamal Greene, who is Dwight Professor of Law at Columbia, where he teaches US constitutional law and comparative constitutionalism, among many other subjects. He too graduated from Yale Law School and clerked for Justice John Paul Stevens before returning to the classroom. Greene publishes in many forms and venues, including a 3-year stint on staff at Sports Illustrated. Go figure. But the work that brings him into conversation with us today is his important first book, How Rights Went Wrong, Why Our Obsession with Rights is Tearing Us Apart, published in 2021. I look forward to an exciting, often surprising, and always inspiring conversation between them and with you all. And with that, I will turn the virtual floor over to Professor Julie Suk.
Thank you so much, Jane. Thanks for hosting this really interesting and important conversation on this interesting day. So on this day, 50 years ago, the Senate voted by a very wide margin, 84-8, to adopt the Equal Rights Amendment. And 84-8 may seem like a landslide, but those numbers do hide the long and drawn out battle that the ERA faced in the Senate in March of 1972. And it faced that battle despite overwhelming support from both political parties and popularity amongst the American people. because a very small number of senior senators who had a reputation for filibustering civil rights legislation and also successfully filibustering the last constitutional amendment proposal that had been brought to the Senate, seeking to abolish the Electoral College. So that very small number of senior senators drew out a very long debate trying to weaken the ERA's protections, trying to change its text, and also to slow it down. And this is an important thing to remember about March 1972, because their effort to stop the ERA, which failed in March 1972, also masks a very important victory that those same filibuster-prone senators had procured in 1970, when the ERA was first passed by an overwhelming majority of the House, which is that when it was first passed, it did not have a 7-year deadline on ratification. But by drawing out debate and not even putting it up for a vote in 1970 and 1971, and then filibustering the Electoral College Amendment, these same very small number of very strong male senators were able to procure a significant victory, which is the 7-year deadline, which then made its way into the version of the ERA that passed in 1971 in the House and March 22nd, 1972 in the Senate. Of course, it's important to note that when the ERA passed, even by this overwhelming majority, despite this battle in the Senate, there was actually only one woman in the Senate at the time, and that was Margaret Chase Smith. She voted for the ERA, but it is pretty incredible when you read the pages of the congressional record when the ERA was debated for hours on end, that really there are no female voices in the Senate. Margaret Chase Smith was at the end of her congressional career, and even though she voted for the ERA, she was not one of its most vocal proponents in 1972. The ERA's most vocal proponents in Congress were actually members of the House in 1971 and 72. And these were trailblazing women like Shirley Chisholm and Patsy Mink, who were among the first non-white women elected to Congress, and Martha Griffiths, who was the primary sponsor of the ERA, and Bella Abzug amongst the Democrats. But there was also very significant Republican Congresswomen support, including by Margaret Heckler and Florence Dwyer. And all of these women from a range of different political and ethnic backgrounds were committed to proposing this constitutional amendment, declaring that equal rights would not be abridged on account of sex, because in their experience, women's second-class citizenship was either assumed or explicitly enforced in many laws and regulations in force at the time that governed most women's everyday lives. Women lawyers, like the late Justice Ruth Bader Ginsburg and the pioneering civil rights lawyer Polly Murray, found brilliant and clever ways of getting many of the laws of American patriarchy struck down through litigation under the 14th Amendment. So during that same period that the ERA is ratified after March 22nd, 1972, throughout the 1970s, that is, during this time that 35 states ratified the ERA, litigation led by feminist lawyers like Ginsburg led to the US Supreme Court issuing landmark decisions that for the first time protected the equal rights of women under the 14th Amendment. And this is interesting that you get the Supreme Court bringing sex equality into constitutional jurisprudence under the Equal Protection Clause on the one hand, while you get 35 ratifications in the states. And of course, if we were going to take a step back and think about constitutions in the world, getting 35 states to ratify a constitutional amendment is significant. That's a supermajority of the states. And if you think about the states that actually ratified, a very large supermajority of the American people, because the states that are very populated ratified the amendment pretty quickly. But of course, under Article 5 of the US Constitution, 35 states is not enough because you need 3/4 of the states under Article 5. So the ERA came 3 states short of ratification within that 7-year deadline. But nonetheless, there was progress with regard to the 14th Amendment, not only in terms of sex equality jurisprudence, but also on due process. The Supreme Court in 1973 in Roe versus Wade protected a woman's right to terminate a pregnancy before viability under the due process clause of the 14th Amendment. And it's because of this progress that was simultaneous with the time that most of the states were ratifying the ERA that many people today think that the ERA is really no longer needed. And so a lot of people will say that the ERA is redundant and superfluous. And these arguments then come into the opposition to efforts to make the ERA survive, largely because 3 states did come through in recent memory. Just in the last 5 years, 3 states ratified the ERA, although way past the congressionally imposed deadline. And opponents say that Congress cannot and should not extend that ratification deadline to validate these late ratifications for a variety of procedural reasons, but also substantively because they think the ERA is redundant and superfluous and no longer needed. And I think as we consider that question as to whether the ERA is now redundant and superfluous, I want to make 2 points. One is just echoing something that Patsy Mink, the first Asian American woman elected to Congress, said on the floor when she advanced the ERA in the House. She said, "It may be redundant to have this constitutional amendment, but there are worse things than redundancy. Among them, the lack of action by our executive, legislative, and judicial bodies to put into effect the equal rights safeguards already in the Constitution." She then said, "The Equal Rights Amendment will awaken our somnolent public servants to the fact that women are people and fully entitled to equal protection of the law. Adoption of the amendment would leave us the formidable task of seeking extensive legislation and judicial actions to implement it in all states and local jurisdictions across the country." And note that in saying this, she was really casting a vision of the ERA as a wake-up call to policymakers, lawmakers, all governmental actors, as something that would actually condemn the lack of action by government to ensure the equal citizenship stature of people of all genders, especially women who were denied it by law for the first 200 years of our nation's history. And if we take that vision really seriously, advanced in 1971, ERA as a nudge or a kick in the pants to all lawmakers, that's a very different vision of rights than what we're used to in American constitutional law. The American Bill of Rights dates back to the 18th century, and most constitutions around the world not only have equal rights for women guaranteed in them, they also have a different vision of rights where it's not just a right against the state, but a right that obligates the state to pursue the particular value or goals associated with the movement for that right. So on this modern 20th and 21st century vision of what a right is, it's the government's job to transform our constitutional institutions, to transform our realities into one that's consistent with the equal citizenship stature of people of all genders, and especially women who were denied equal citizenship stature for so long. And certainly in our peer democracies like France and Germany, and also in the Ukraine, which has a constitution that dates to 1996. And I mention it because it's a nation that's literally fighting against violence to save its democracy. In the Ukrainian constitution, there's a guarantee of equal rights to women and men, which explicitly means that government must take action to eradicate women's disadvantages and underrepresentation. And I want to just hold this up because so much of the argument for the ERA is not just about women's rights as such, but for a modernization of the US Constitution in a manner that would be consistent with constitutionalism and the women's rights in many of the constitutional democracies around the world. If you look at this much more modern, sort of very late 20th century gender equality provision in the Ukrainian constitution, Article 24 reads, equality of the rights of women and men is ensured by providing women with opportunities equal to those of men in public and political and cultural activity, in obtaining education and in professional training, in work and in remuneration, by special measures for the protection of work and health of women, by establishing pension privileges, by creating conditions that allow women to combine work and motherhood, by legal protection, material and moral support of motherhood and childhood, including the provision of paid leave and other privileges to pregnant women and mothers, right? So that's Ukraine's ERA has 3 times as many words in the text than our proposed ERA text. But those words show you what the ERA can mean. That is, in modern constitutions, the idea that a guarantee of equal rights to men and women, or a guarantee of equal rights unabridged on account of sex, is a vision that says government has to work harder to ensure equal citizenship stature in all aspects of life and in public policy making. So, of course, in France, Germany, and many constitutional democracies that guarantee equal rights to women, laws passed over the past quarter century have supported women's access to political power beyond the vote, so much beyond what our 19th Amendment achieved. We had only one woman in the Senate 50 years ago, and Congress now has about 25% women today. But that is actually a lot less than most of our peer democracies where women constitute 40 to 50% of lawmaking and decision-making positions. And this has occurred not just because of cultural change, but because of laws that actually mandate quotas or other measures to overcome women's disadvantage and underrepresentation. And so what the equality amendments in other constitutions have done is to legitimize and to authorize those provisions. Because one conflict we've often faced in the context of our equal protection guarantees is that when government acts to alleviate disadvantages or underrepresentation, for instance, through affirmative action, it is often challenged based on the claim that it violates equal protection rights to non-discrimination of other groups, including white people or men. And that's a particular conflict that I think a more modern understanding of gender equality provisions in other constitutions has been able to overcome. So I want to conclude by saying that we need a constitutional amendment to get into this mindset of equal power. But that mindset, it's not necessary to achieve gender justice in all the ways that the Ukrainian constitution and other constitutions may spell out, but it can be just the beginning of an America that many of who I think of as the founding mothers of the ERA, Shirley Chisholm, Patsy Mink, Martha Griffiths, that's what they hope to see 50 years from then. And of course, the ERA, the fight for the ERA continues. And I'll just close by saying that in telling the history of the ERA and what happened 50 years ago today, I can't emphasize enough the problem of unequal power. That is, that despite overwhelming support for the ERA, it failed. It failed in part because of a 7-year deadline that was a product of, I think, a highly imbalanced political compromise. And of course, that 7-year deadline derailed the ERA because state legislatures had a range of rules that avoided a full debate on the ERA in some of the state legislatures that failed to ratify it. And so in order to really think about the promise of the ERA as something that's continuing and alive today, there needs to be less attention to rights and more attention to the ways in which our institutions of democracy have power imbalances that actually undermine democracy and women's contributions to it.
Thank you, Julie.
I'm going to cede the virtual floor to Jamal Greene.
Thank you, and good afternoon to everyone. And I want to say thank you for including me in this important conversation about the Equal Rights Amendment. And I'm especially honored to share the virtual stage with these two women, Jane Kamensky and Julie Suk, the latter of whom has written a terrific book about the ERA, and I think is within the legal academy certainly the leading expert on the Equal Rights Amendment. I am a scholar of constitutional law and constitutional theory. I dabble in comparative constitutional law, and I've also written a book about the US constitutional tradition. And I want to spend this relatively brief time I have at the start of our conversation addressing the question that actually I think picks up very nicely on what Julie Suk had to say about what passage of the ERA would or could or should actually accomplish as a matter of constitutional interpretation. And now, why is this an especially interesting question? I think if you were to poll a bunch of US constitutional law professors, and I'm sure Julie Suk has been in rooms where this kind of conversation happened, and you were to ask them what ratification of the ERA would accomplish, I think a big chunk of them, and maybe a majority, would say nothing. There's a narrative within the field that says that the sex equality goals of the ERA have in fact already been accomplished. A lot of that narrative, I think, can be summarized by referring to an exchange between Justice William Brennan and Justice Lewis Powell in a 1973 Supreme Court case called Frontiero versus Richardson. The dispute in Frontiero was over whether the US military was allowed to treat male and female service members differently in the administration of spousal benefits. At the time, male service members received them automatically for their spouses, but female service members had to prove that their spouses were actually dependent on them for support. And the interpretive question in the case was, what is what lawyers call the standard of review for this particular law? Should the court apply the default standard of review, which is where the government kind of wins, basically, so long as there's any rational basis for the law being passed? Or should the court apply a presumption of unconstitutionality, so-called heightened scrutiny, on the ground that discrimination on the basis of sex, just like discrimination on the basis of race, is inherently suspicious? At the time of the decision, which again is 1973, the court had never formally applied a heightened standard of review to sex classifications by the government. So, which brings us to the exchange between Justice Brennan and Justice Powell. The question for them was, or one of the questions they chose to discuss is, what impact would the Equal Rights Amendment have on this question? The ERA had passed Congress overwhelmingly the year before the case was decided. It had been ratified by 30 states in the year since it had been passed by Congress. But the two justices, Justice Brennan and Justice Powell, drew exactly opposite conclusions from the fact that it had been ratified or passed by Congress and supported by these states. On the one hand, as Justice Brennan said, the level of political support for the Equal Rights Amendment meant that the American people viewed sex equality as a matter of high importance, right? And therefore, sex discrimination should be viewed as presumptively unconstitutional. On the other hand, as Justice Powell said, the American people were in the process of determining the constitutional status of sex equality. And so the courts should not preempt their judgment by deciding the question judicially. Now, in a sense, Justice Powell won that exchange in Frontiero, in the sense that even though the law was struck down in that particular case, there was not a court majority for applying a heightened standard of review in the case. Now, 3 years later, the court compromises by applying a heightened standard of review that isn't as high as the standard of review for race, right? So race and sex end up being treated differently. But in the years since the 1970s, it has been difficult, though not impossible, for overt government sex discrimination to be upheld by courts, right? And so, again, according to the standard narrative, the very same social movement energy that led to the ERA getting as far as it did actually makes the Supreme Court change the way it looks at sex equality. And we can credit Reva Siegel at Yale Law School for the term de facto ERA, which suggests that the ERA is essentially brought on by lawyers like Pauli Murray and Ruth Bader Ginsburg, and by the social movement and political movement that leads to formal failure but informal ratification. But the question then becomes, right, if we have a de facto ERA, what do we need a real one for? And I want to suggest that there are some very good interpretive reasons to say that, in fact, there is a lot of work that the real ERA can accomplish, even though I agree that the Supreme Court treats sex discrimination as presumptively unlawful. The first thing I'll say is that maybe somewhat perversely, there are ways of thinking about this that would suggest that the ERA would actually be bad for women's equality in various ways, insofar as the Supreme Court has a very kind of formalistic understanding of equality rights that suggests that they should be viewed entirely symmetrically, so that even laws that were designed to be helpful to women might be struck down under an ERA because there's this very heightened standard of review to be passed. I think that's certainly not the only way to think about the ERA, and I think it's very, very far from the best way of thinking about it. But I just thought it's important to put that on the table, given where the modern Supreme Court is on equality rights. One feature of the ERA that makes its interpretation extremely interesting, right, is that unlike most constitutional amendments, it's been drawn out over such a long period of time, right? So first ratifications occurred in 1972. If we consider Virginia to be the 38th ratification, that happens in 2020, and of course there's controversy about that. But that's a 48-year period during which attitudes about the subject of the amendment have changed dramatically, and they've changed dramatically across the political spectrum. So, for example, the mainstream view in 1972 was that the ERA would not forbid discrimination on the basis of sexual orientation. The idea of discrimination on the basis of transgender status was barely an intelligible thing to say in 1972. But in 2020, the Supreme Court, in an opinion by Neil Gorsuch, held that sex discrimination, in fact, does include sexual orientation discrimination, or at least under Title VII, the federal anti-discrimination law. Now, for a living constitutionalist, right, this would suggest that the ERA may, in fact, require something different now, substantively, than it did when it was drafted and ratified. But even for originalists, right, it might well be that the meaning of sex equality now, rather than back then in 1972, is what really matters. We might say something similar about the consequences of the ERA for sexual harassment by public officials, for example, which was not understood to be encompassed within sex discrimination in 1972, but is broadly understood to be encompassed within sex discrimination today. There's a broader interpretive inference that one can draw that makes the potential passage of an ERA not just consequential, but I think quite revolutionary in ways that Julie Suk has already suggested. The fact that the Equal Protection Clause of the 14th Amendment is already read to make official formal sex discrimination presumptively unlawful means that the ERA, if passed, should ordinarily, just as an ordinary act of interpretation, be read to go further than this. Otherwise, what would be the point of passing it? Indeed, the Equal Protection Clause doesn't single out any specific ground as a particularly disfavored ground for discrimination. not even race. That's not even textually singled out as a particularly disfavored ground. So passage of the ERA would place sex equality in a favored constitutional position as compared to other forms of inequality. So forms of equality. So U.S. constitutional lawyers, and I emphasize U.S. here, consistent with what Julie Suk said, tend to have trouble conceptualizing what it would even mean for sex equality to be placed in a more favored position than it is now. But just looking around the globe reveals that that's a limited imagination about what constitutional law can mean and can require. There are any number of ways beyond formal equality in which equality of rights may be abridged on account of sex. For example, under US constitutional law, laws that have a so-called disparate impact or disparate effect, but that are not intentionally discriminatory as to a particular class or category, can't form the basis for an equal protection claim. And yet, disparate impact, or what people around the world call indirect discrimination, is a common ground for discrimination claims around the world. It's not at all unusual globally to think about constitutional law in terms of the disparate impact on particular groups or populations. It would seem to me to be a fairly ordinary interpretive inference to say that the ERA goes beyond the Equal Protection Clause to reach substantive inequality. That is fairness of outcomes and not just opportunity. There are any number of laws that disproportionately affect women, even if they don't formally target women as a class. Anti-abortion laws are one obvious example of that. Beyond simply thinking about disparate impact or indirect discrimination, interpreting the ERA as something distinct from the 14th Amendment and distinct from the Equal Protection Clause also seems to me to invite some consideration of the positive aspects of rights, right? We tend to think of, in the US, we tend to think of rights in essentially negative terms, right? As the right to not have the government do a certain thing to you or to take something away from you. But rights also have positive elements, as in the right to be provided with the resources that one needs in order to enjoy a particular right. And in the context of sex equality, this might mean, for example, the sorts of things that Julie Suk mentioned about the Ukrainian constitution, right? Thinking more holistically about what the state can do to support families, for example. The lack of support for families has a disparate effect on women who are so often bear the social burden of being caretakers. Again, it seems to me fairly ordinary as a matter of interpretive inference to say that the ERA might require some kind of paid family leave, might require some kind of childcare support, might require some kinds of employment guarantees for women after they've given birth, might require some kind of support for elder care to relieve women of the disproportionate burden that they bear in that domain as well, right? And so forth. There are any number of ways to think about this. And in fact, I think because the potential scope of what sex equality might require in substantive terms is so broad, I would actually place a great deal of emphasis, as I think Julie Suk has as well, on the second sentence of the ERA, which empowers Congress to enforce the ERA by appropriate legislation. And so it's not just about judicial enforceability, it's also about giving the political branches the power to reach particular substantive areas. And so I think rightly understood, an ERA should empower Congress to enact a wide variety of measures around equality in the workplace, around family law, around reproductive freedom, around educational and health measures that are designed to ensure substantive equality on the basis of sex. So, and for a variety of reasons, it's not at all clear that Congress has the power to pass that full range of measures today. Now, of course, the trick is getting it ratified or getting to a consensus that it has been ratified. But until that happens, I think it's important to develop the kinds of arguments that will be needed about what it might actually mean. So I'll cede the floor and pass it back over to Jane Kamensky for the discussion.
So thank you both, Julie and Jamal, for such a feast of things to talk about. I have a couple of questions that I want to hear you both on, and a couple of questions that I want to direct in turn to each of you. And please, members of the audience, put questions in the Q&A function. Some are already there that we can turn to next. So I guess I want to ask you each to take us back to a moment in time in your broader story, Julie to the 20s and Jamal to the 60s and 70s. So Julie, I'm thinking of the Finish the Fight slogan that carries suffrage messaging over the finish line between 1913 or so and ratification in 1920, and the common understanding, you touched on it in your remarks, that the ERA is the necessary second act to suffrage. Tell us a little bit about how we should think of the idea of ERA and the early parts of the journey of ERA with respect to the 19th Amendment.
Well, certainly, I think that the movement for suffrage went together with the movement for equal rights. If you think back farther in time to Seneca Falls and the Declaration of Sentiments, so many of the demands were about the kinds of things that the ERA would go against or would invalidate, like married women's property rights. And so, but of course, suffrage becomes the primary fight in the late 19th and early 20th century. And so when that amendment was successful, there was amongst those who were most militant within the suffrage movement, the National Woman's Party and Alice Paul, they really believed that the ERA was the next step, that suffrage was just the beginning and that the ERA was the next step. But this ended up dividing the women who had united behind the suffrage cause. And it was because, I think, just to pick up where Jamal was talking about, between different negative and positive understandings of what rights could do. Because one understanding of what it would mean to have equal rights was complete sameness of treatment, particularly when it came to laws. So the idea that was advanced by the proponents of the ERA at the time was that laws that gave special protection to women in the workplace in order to shield them from exploitation in the context of a larger constitutional framework in which the Supreme Court was striking down all labor legislation on the theory that it was a violation of people's negative right to freedom of contract. In that context, the ERA could have been extremely disastrous for protections for women workers. And for that reason, a lot of the advocates of suffrage who are also advocates for workers' rights and particularly the rights of working class immigrant women, did not want to put all their weight behind the ERA. And it's that fight about labor rights that I think really derails the ERA. And of course, this is not this is a very American story, because if you look at other constitutions around this time, so the Weimar Constitution in Germany, right after women get the vote after World War I, they are actually elected in large, well, not hugely large numbers, but significant numbers to the Constituent Assembly at Weimar, and they put in an equal rights provision. But of course, it never occurs to them that an equal rights provision is going to be no labor protections for women. They also put a provision in their constitution that says motherhood deserves the special protection of the state. And so it's understood that women can get special protections even under a regime of equal rights. So I think it's true that maybe in some theoretical sense, equal rights is the logical next step, or even just part of the same bundle that suffrage is supposed to be about. But it's very interesting to see how the background legal context in which that's proposed can kind of make that sequence or disrupt that sequence and make it seem not the right move after political rights.
Thank you so much for that. And Jamal, if I can ask you to root us in a different way in the 60s and 70s, a period which you and your book refer to as a rights explosion, with both tremendous and necessary victories and unintended consequences. I want you to help us situate the ERA in that story of struggle over realizing multiracial democracy in that period of rights explosion.
Sure. Well, one of the ways in which U.S. constitutional law differs from constitutional law in a lot of other places is that we tend to think about rights in terms of categories, right, in categorical terms. There are certain kinds of rights that are presumptively absolute, and the Supreme Court thinks of race as the kind of paradigm for presumptively absolute rights, or rights against racial discrimination. And there are other kinds of rights that get complete deference from courts. And that categorical frame carries the baggage of reconciling a couple of different lines in US history. One is actually mentioned by Julie just now, which is a backlash against a period in which courts were not very deferential when it came to ordinary labor legislation and health and safety measures. And there was a backlash against that in the late 1930s. And the other line is Jim Crow, where you've got this pathological governance, where the state just can't be trusted at all. Because the state is pathological. The state is in the hands of white supremacists. And so if you think of rights in terms of that, it becomes hard to think about rights in incremental terms, or to think about rights in terms of being something that gets developed politically, or defined politically. You think of judges as the heroes who save us from the pathologies of the state. And when we get to the 1960s, when there's, as I say, an explosion of rights, people are making rights claims in a lot of different contexts, whether it's free speech, whether it's the criminal justice space, whether it's the sexual revolution, whether it's social welfare, and people claiming rights to have certain welfare provided by the government. Just a very wide range of settings in which people are kind of newly making rights claims. And courts are trying to fit them into this dichotomy between sort of really, really strong rights and not as strong rights. And that's a really difficult position for courts to be in. When we get to the 1970s and the ERA being finally passed by Congress in 1972, there's a lot of discussion of the race analogy, analogizing sex to race. And if we think about race as this presumptive thing, you can't, governments can't discriminate on the basis of race. If they can't discriminate on the basis of sex, oh my goodness, it's going to mean that women are going to be drafted into combat, and it's going to mean that there won't be any more gendered bathrooms, and those become rallying cries around which the discussion is framed, and those end up being, I think, distractions, so the analogy makes it easier to demonize the ERA as something that felt radical at the time, and so ironically, the fact that courts were led through the civil rights movement to take race seriously for the first time in American history meant that it was harder to take other things seriously, because everything was constantly being analogized to race. So rather than think about the ways in sex discrimination and sex equality on its own terms, right? There are ways in which it overlaps or is similar to race discrimination. There are ways in which it isn't. There are ways in which these are, of course, intersectional and overlap. There are people who are racial minorities and women, of course, and so rather than think about those things in their own terms, we end up sort of trying to hive them off into these categories. That makes it easier to associate, in a kind of rhetorical sense, the ERA movement with the other very, very live issue at the time, which was busing. and to associate it with abortion rights, which is also a racialized issue at the time. So these things get bound up in ways that make it difficult to think about sex equality in its own way, on its own terms, with its own parameters.
Thank you. And there's a pair of questions coming from the audience that builds on that about coalition building. And I'll throw this to Julie first as the person who has worked a lot on the social movement. And so can either of you envision a bipartisan amendment or movement fighting for equal rights for women in the future? Could you imagine a coalition in which the GOP went back to its position of the 70s? A related question notes that feminist coalitions are so hard to maintain with so much diversity within groups, and asks historically what has worked best in terms of holding coalitions together.
Well, I'll preface this by saying that I have a very wild imagination, in part because I study many places in addition to the United States. But I will say that the fact is that we cannot have constitutional amendments without a tremendous amount of consensus in this country, 2/3 of both houses of Congress and 3/4 of the states. And we haven't had a constitutional amendment since 1992. And I think the reason is that it's just not possible now to think of 2/3 of Congress agreeing to much of anything, and then 3/4 of the state legislature. So it's a very, very high bar. But I think to the extent that amendments in other countries operating under lower bars with regard to what it takes to get constitutional amendments or an original provision passed within a constitution, I think it's always involved a coalition of women across the political spectrum. And one of the unifying themes, I think, has been motherhood. And I think right now we're at a pivotal moment where the pandemic, the COVID-19 pandemic, really laid bare what happens when schools shut down and childcare shuts down. A lot of the burden, which women were bearing, disproportionate burden for childcare, even before the pandemic, just gets amplified and more visible. So I do think that there has been some possibility for left-right coalitions around things like childcare or the need for more public support to make parenting easier, particularly when the burdens of parenting and the disadvantages, economic and otherwise, associated with caregiving burdens tend to fall on women. I also think there has been bipartisan coalitions within Congress, amongst women in Congress, around issues of sexual violence in the military. So I think to the extent that there's any possibility for bipartisan work, I don't know if that possibility would get to the level of what it takes to normally have a constitutional amendment in the United States. But I think that the kind of purple issues have to be around motherhood and violence against women.
Thank you. And Jamal, do you want to respond as well?
So I don't have much to add beyond what Julie said. I will say I'm certainly cynical about the possibility that there's anything, a substantive that around which one could develop a sufficient bipartisan consensus to pass a constitutional amendment. I think, thankfully, in the case of the ERA, I think the more likely way of getting to at least something of a consensus that it's actually been passed would be an ordinary congressional statute extending the deadline, and maybe some re-ratifications by states that have attempted to rescind their ratifications. I think that I don't know the political possibility of those things happening, but they're much more likely than a fresh constitutional amendment being passed, which I think can't really happen on anything of substance in the foreseeable future. I will say that as Julie said, the ERA has quite broad language. It's a feature, I think, of the amendment rather than a bug, that the language is very broad, and can be interpreted in a number of different ways. I think that's the only way you can get a consensus or a sufficient coalition together, that people who have the different stakes in the passage of the amendment or a passage of a bill see it in different ways. And that's there's nothing problematic, I think, about that. That's the case of the Constitution itself, and lots of other amendments that different groups and different people with different interests have different motivations for wanting a particular language to be passed. But so I don't think it's impossible. I think, as with many other things, there's a struggle to achieve anything of substance in a bipartisan way. But it is sufficiently broad that I don't see it as impossible that that you could get it over the finish line with some bipartisan buy-in.
Of course, that breadth was also key to bringing together the opposition coalition, which is in its own way very broad across confessional lines in a way that hadn't been seen before, and where this is Jenny Mansbridge argument. Of course, the spareness of the language allows a number of nightmare scenarios to be woven that also coalesce in particular ways. I also wanted to just underscore something that was clear in both of your comments of an imagined future with an ERA is a future of constitutional modernization that could maybe think about ways to move past the impasses that that our amendments process gets us into, which leads me to a couple of audience questions about the specifics of the liminal status of the amendment. Now, we have one question that asks that we reflect on the 202-year journey of the 27th Amendment without deadline, and its relevance to the possible legitimacy of the actions by 3 states in the last several years in Nevada, Illinois, and Virginia. And then a flip side of that coin, a guest from West Virginia asks how to make their state's ratification rescission proof as energy gathers there now. So branching off from those questions, thoughts about the contemporary status and where we can and where we might go. Julie, you want to kick us off?
Sure. So I guess the questioner raised the 27th Amendment. So the 27th Amendment was an amendment that was part of the original Bill of Rights that was proposed in 1789. It's called the Madison Amendment because James Madison wrote it. And it was an amendment that just said that if Congress voted to give itself a raise, that raise didn't go into effect until after an intervening election. It was not ratified and made part of the Constitution along with the original Bill of Rights. And a few states ratified it in the 19th century, a few states ratified it in the 20th century. And then after the ERA was presumed dead, because it wasn't ratified by enough states by the extended deadline in 1982, some states started in large numbers ratifying that Madison Amendment because they said, well, that's an amendment that didn't have a deadline. They weren't really thinking deadlines in 1789. And so 38 states ratified it by 1992. So that's the last time we actually had a constitutional amendment. It was an amendment that actually dates back to the 18th century. But I think because of the success that was added to the Constitution, and because of that, many people started saying, so obviously the age of an amendment does not disqualify it from being ratified, continuing to be ratified. And that's how the ERA revival movement that led to the 3 ratifications in the last few years succeeded. The very important difference, though, is that the ERA, like many of the amendments that were added to the Constitution in the 20th century, did have a congressionally imposed deadline. And there's a lot of parsing about the significance of that because the deadline was put into the preamble of the resolution that Congress passed, not into the text of the constitutional amendment itself. So there are debates amongst constitutional scholars about what its legal status is. Does it bind the states? Is it just advisory? Is it just something that Congress is saying it's definitely part of a constitution if you get it done within 7 years, but if it's not, then what? It's ambiguous. And so my view has always been, and consistent with Supreme Court precedent, like cases like Coleman v. Miller, that it's really just up to Congress. In this moment where it's not clear, Congress is the one that imposed the deadline. Coleman v. Miller and other precedents suggest that Congress has the power to put deadlines in. If Congress has the power to put deadlines in, it must encompass Congress's power to remove the deadline or to extend the deadline. And certainly by that logic, the ERA's deadline was extended once in 1978. And there is support in Congress. The House has passed twice now a resolution removing the deadline. It is widely believed that there's enough support in the Senate to pass that resolution, but because of the filibuster, it probably will never come to a vote. If it did come to a vote, there would be 51 votes to possibly 52 votes to remove the ERA deadline. And this just gets back to our thinking about our basic political institutions and how democratic they are. Because given that we have 38 ratifications and probably 2 houses of Congress willing to extend the deadline, but congressional procedures that make it highly unlikely that that's going to happen. That's, I think, one of the features of our constitutional system that is in need of serious democratic modernization.
Thank you, Julie. And Jamal, can I ask you to address briefly the flip side of rescission? So we have the rescissions that have already been claimed, and we have West Virginia moving in that direction in its state legislature. Any words of advice from our guest from West Virginia about processes that interrupt such a campaign, or your views of the status of rescinded ratifications?
So, I think the only surefire way of ensuring that a ratification can't be rescinded is to pass the amendment. So that's the Constitution, and certainly you can't rescind a ratification after the amendment has already become a part of the Constitution. Whether you can do it beforehand remains an unanswered question. I really don't have a considered view about it. This is the sort of thing that that is what we although I don't know that the Supreme Court would agree, is essentially a political question, the kind of question that is resolved through political discourse more than being a strictly legal question. Article 5 of the Constitution just doesn't answer this question at all. And our practices over the years have included attempts at rescission, and certainly within the context of the ERA itself. But in terms of getting something over the line, it hasn't become relevant yet.
So I've gotten the hook from my colleagues saying that we have time for one more question, and I'm going to ask you a sort of lightning round question about social movement energies. Of all the things in our democratic institutions that we could be fighting for, why should or shouldn't we devote some of our bandwidth to fighting for an ERA in 2022 and beyond? And Jamal, I'll ask you first, and Julie, have the last word.
Well, I'll just say very quickly, I think the ERA is worth fighting for, because I think that there is quite a lot of potential within the ERA to think about women's equality in substantive terms, and to think about it in terms of actually supporting women in the ways in which the positive social facts of our life impose burdens upon them. And I think that's as important as anything within our society.
So I agree with everything Jamal said. And I think that there's an added dimension, which is constitutional modernization. I think actually the fact that we haven't had an amendment since 1992, I wasn't even old enough to vote yet, and now I'm comfortably middle-aged. But I just think that in many healthy constitutional democracies, people think of themselves as potential agents of constitutional change. And I think we've lost that in the United States. And we have a pretty antiquated idea of what a right is because of our lack of access to formal constitutional amendment. And if you look at what's going on in Chile, they're writing a new constitution. In Ireland, they've had citizens' assemblies that have proposed amendments, many of which have had to do with gender equality and abortion. And so I just think that we need a space in which people feel that the Constitution can be changed to reflect 21st century values and commitments. And I think that pursuing the ERA, because of the substantive reasons that Jamal pointed to, is a really important factor for that.
Thank you both for a conversation that I think was as fresh and creative, original, well-grounded group of lenses on this vexing problem we could possibly have got. I want to again recommend both of these books in conversation with each other to our audience. And thank you all for being here today on this anniversary.